welcome to Navigating GDPR, the Art of the Possible. Navigating through rough water takes skill and experience. The GDPR is a long and complex mix of principles and practical steps, making it a challenge for everyone. This year's conference theme is the art of the possible, reflecting a realistic assessment of the task ahead. We start from different points of the compass and may have a common map, but no clear finishing line. Rather like the EU data protection regulation compared with the European Community Directive from 1995, the outline is familiar, but the details are different. What of the UK's position? Those favouring the UK leaving the EU would prefer a Rule Britannia approach. But there are alternative models for the UK, which we've been exploring and will explore at this conference. The Iceland-Norway model, European Economic Area, or the Swiss trade agreements and single market model, or indeed the Turkey Customs Union model. Dinner last night, we heard from lawyers from both Switzerland and Turkey on how data protection law works in their national context, influenced by the EU. Tomorrow, we will hear from the head of Iceland's Data Protection Authority, how a country can work happily outside, but alongside the EU, participating in the European Data Protection Board. In the lead story, which you see there, analyses the national specifics which throw light on the regulation for every country and sector. He wrote, "As you know, the GDPR in many ways is not a true regulation, but resembles a directive. To some degree, it will be an illusion that there is a common and unified data protection law across Europe." He gives examples, and I'll mention just one, financial penalties. He wrote, "It is common knowledge that it is the increased fines that have placed data protection high on the public agenda and meant the GDPR has attracted broad interest. Improved data protection is not due to love, but to fear." We also publish our UK report 6 times a year in alternate months, also both electronic and paper formats. We often interview leading figures in the data protection world, some of whom write for us. Some of the reports from our own events, some of the reports are indeed from our own events, such as the GDPR Help Roundtables, which we've run over the last couple of years. And the next one is on the 28th of November in London. Now, why do you get that look whenever we talk about GDPR compliance? This may have been a common reaction when you first started to talk about the GDPR in your organisation or to your clients. But for us, deeply involved in the GDPR, this has been an opportunity to attract the attention of top management, to win more staff and other resources for data protection work, such as audits and training, and improve operational management systems. And we can also help to make a strategic case for developing a GDPR strategy, which has a business development dimension. An example is Microsoft's announcement in May that is taking on board the GDPR across the world, not just in Europe. Of course, this policy increases the revenue potential of Microsoft Cloud services, but at the same time, Microsoft makes a clear distinction between itself and other US tech companies such as Facebook, which claims that it's adopted the GDPR where it has to by law, but not in the countries outside Europe where this gold standard is not required. Many of us expect that this next story from China represents the creepy or scary end of the spectrum. This story from the Hong Kong-based South China Post on the 29th of April this year has the headline, "China is mining data directly from workers' brains on an industrial scale." The story continues that the Chinese government-backed surveillance projects are deploying brain-reading technology to detect changes in emotional states in employees on the production line, the military, and at the helm of high-speed trains. You can see the train driver's helmet in the lower part of the screen. A technology company in Shanghai says that its brain monitoring devices are worn regularly by train drivers working on the Beijing-Shanghai high-speed rail line. And the sensors built into the brim of our driver's hat can measure various types of brain activities, including fatigue and attention loss, with an accuracy of more than 90%. If the driver dozes off, the cap triggers an alarm and to wake him up. So there is a point to it. This cartoon by the prescient Chris Lane, son of the first New Zealand Commissioner, Bruce Lane, was from 20 years ago. Shows that the value of personal data can far exceed the value of gold, which explains how Facebook and Google have become amongst the world's most highly valued companies. Norway's Consumer Council has published its research into Facebook and Google's methods of collecting personal data, and they are very critical. Facebook and Google, they say, quote, Facebook and Google steer us into sharing vast amounts of information about ourselves through cunning design, privacy invasive faults, and take it or leave it choices. Their conclusion is that these companies appear to have little intention of giving users actual choices. So they say that the companies are manipulating people, and certainly other consumer bodies, BERC, the European Consumer Organisation, has picked up the baton, and they're now engaging both in Europe and consumer organisations in the US by contacting European data protection authorities and making complaints. So there's a sort of an attack on excessive collection of personal data by consumer organisations. So at the European level, Monique Goyen, Director General of the European Consumer Organisation, BERC, say that companies have to respect the letter and the spirit of the GDPR. At a European Commission conference in Brussels on GDPR Day, 25th of May, I asked her whether she expected consumer groups to use their new collective rights of action under Article 80 of the GDPR against companies. She said yes, and such complaints have already been made to the national data protection authorities in Austria, France and Ireland, and that was on GDPR Day 1. So we watch these developments, and as a result of these developments, we're organising a conference in Brussels on 20th and 3rd of October, specifically on this area of civil society action and collective action under GDPR. Other forces are bearing down on companies that are collecting, or seen to be collecting, too much data. This represents Germany's powerful Federal Cartel Office, the Competition Office, which announced on 19th of December last year that Facebook is abusing its dominant position, or it was investigating whether it's abusing its dominant position, was what it was about. And so they've made a case, and Facebook are responding to that. It's all to do with, is the collection of personal data excessive, and the sharing of data with Facebook subsidiaries and other operators. Federal Trade Commission in the US is also getting actively involved, and they're holding some hearings later this year into the collection of personal data and potential abuse of dominant position, and intersection between privacy, big data and competition policy. So there's an attack on companies' excessive collection of data on all sides. And finally, the boy standing in front of the teacher says, before I write my name on the board, I'll need to know how you're planning to use that data. A fine example of purpose limitation, the subject of our first session. I declare this conference open.